Good afternoon, class. My name is Matt Gilbert, and the topic I chose to study is music copyright law. First, let's get a basic understanding of what music copyright law is. Music copyright law gives the legal owner of a musical work or sound recording exclusive rights to reproduce and redistribute the work, create new works based on the original, publicly perform or display the work, and earn royalties through licensing. As I mentioned, there are only two musical copyright protected works. One is a musical work and one is a sound recording, and it is important to make a distinction between the two. A musical work is the song's underlying composition along with any accompanying lyrics, usually made by a songwriter or composer. A sound recording is a series of musical, spoken, or other sounds fixed in a recording medium, such as a CD or digital file. Sound recordings can be made by the producer, performer, or many others. For example, if you take the song Comfortably Numb by Pink Floyd, the rights to the musical work would belong to David Gilmour and Roger Waters, who wrote the song together. And on the other hand, the sound recording rights at the time would have belonged to whatever their current record label was and the band itself, Pink Floyd. An important aspect of music copyright protection is to see how long they last. Any music copyright created after January 1st, 1978 will last for the life of the creator plus 70 years after their death. Now, works like anonymous works, pseudonymous works, or works made for hire last for 95 years after the publication date or 120 years from when the work is created. An example of pseudonymous work would be Travis Scott copywriting his music under the stage name Travis Scott. However, it is important to specify that when he would be registering for a copyright, he would have to use his legal name, Jacques Berman Webster II, in the process to ensure legal protection. On the public copyright database, an artist like Travis can use his stage name for public attribution. Music was not always recognized in terms of copyright protection. It was not mentioned under the original Copyright Act of 1790. However, in 1831, part of this act was revised and musical works were made eligible for copyright protection. Then, the Copyright Act of 1909 allowed only sheet music to be a protected element of music. In the 1970s, multiple copyright acts were passed that affected legal rights to musical works and sound recordings. Congress noted that copyright protection can be applicable for, and I quote, original work of authorship fixed in a tangible medium of expression. This means that whenever the artists compose a piece of music, there is a de facto copyright in place, and it is enforceable. However, artists should always go through the legal process of obtaining a copyright to ensure they can pursue legal damages if someone uses their copyrighted work. In 2018, the Music Modernization Act was passed, which ensures that artists will be paid their royalties for their music. The court case I'll be looking at concerns the plaintiff Pharrell Williams versus the defendant, the Gaye family, and Bridgeport Music. As I hope most of you know, Marvin Gaye released a great song in 1977 called Got to Give It Up. Then, in 2013, Pharrell Williams and Robin Thicke released a song called Blurred Lines. The Gaye family decided to file a copyright infringement claim against Robin Thicke and Pharrell Williams because of similarities between the songs. In response, Williams filed a declaratory relief, which marked for the beginning of the litigation. There were exactly 8 similarities brought to the attention by the defendant's counsel. These included, and I quote, consisting of the signature phrase, hooks, hooks with backup vocals, theme X, backup hooks, bass melodies, keyboard parts, and unusual percussion choices. Gaye's song was copyrighted under the 1909 Copyright Act, which only protects legal rights of sheet music. Sandy Wilbur, a musicologist hired by the plaintiffs, denied all these similarity claims, but was unable to substantiate them in favor of the jury. Another musicologist, hired by the Gaye family, stated that nearly every bar of Blurred Lines had a similarity to Got to Give It Up. The court found that there was evidence of a copyright infringement upon the song Got to Give It Up, and the jury claimed that things like the feel of the songs were too similar and claimed that Gaye's song had protectable elements to it. Then, Robin Thicke and Pharrell Williams decided to appeal this decision in the U.S. Ninth Circuit Court of Appeals, and they claimed that the expert testimony did not correctly reference sound recordings, as technically Got to Give It Up was only covered by the 1909 Act, which only protects sheet music. The plaintiff also claimed that there was some jury bias. The issue here is that the 1909 Copyright Act must be relevant to this case. The reason the plaintiffs challenge this is because certain grooves and things like the cowbell sound are technically not written down within the sheet music, considering that those are not protectable elements. The court had to decide whether the 1909 Copyright Act protected these certain elements, the expert testimony relied on protectable elements, and that the damages awarded were excessive. The court upheld the trial court verdict, saying that the plaintiffs did violate the copyright law. Also, the expert testimony was deemed as relevant and that it did support the evidence of copyright infringement. In conclusion, music copyright law gives the legal owner of musical work or sound recording exclusive rights to use and distribute their music. If used by someone else without permission, it can result in litigation with severe penalties. Thank you.